State, you may give your opening statement.
Anyone good with the notepad? Does anybody need anything?
Okay. I'm sorry, Mr. Anderson, I could not find your chart.
Oh, well,
Okay.
I'll go without it.
May I move the podium, Judge? Good morning again, ladies and gentlemen of the jury. Last week, you found Mr. Hayes guilty of 3 counts of first-degree premeditated murder. And now we're at the second phase of this trial. And this is the phase where you are asked to consider whether or not the death penalty is an appropriate sentence for Mr. Hayes. We discussed this phase quite a bit at jury selection. We spent actually the majority, I would say, at jury selection talking about the death penalty, finding out your views on it and your thoughts on it. And that's because it is such a heavy responsibility to have to make this determination. And I want to thank you all for the time and attention you're going to give this decision, because based upon jury selection, I believe that you can take this weight and go forward with that choice. And as noted at jury selection by the judge and by Mr. Lewis and myself, the death penalty is not sought in every single first-degree murder case. It is in cases that have unique characteristics.
Yes, sir. That was okay?
Yeah, you want one?
Okay. That's fine. Go ahead. You may proceed.
Thank you, Your Honor. As I was saying, there are some first-degree murders, like this case, that based upon the specific factual circumstances, based upon the evidence that you heard last week, where the death penalty is appropriate. And as I said, the question of guilt is no longer at issue. It's now the state's solemn responsibility to present you with evidence of aggravators. And remember, as the judge just said, aggravating circumstances are laid out by Florida law. They're actually listed in a statute, the different aggravators the state can pursue and allege in a death penalty proceeding. And in this case, these statutory factors have actually already been presented to you. The evidence that we are going to show you was presented during the guilt phase. And we're going to summarize that a little bit. I'll do it a little bit in my opening, and Mr. Lewis will do it in his closing about that evidence that you already heard. The only new information the state will be presenting to you is the victim impact evidence. And that will be from members of the family, from Ms. Gunther, Ms. Patton, and Ms. Green. You'll also be asked in this penalty phase and be presented testimony about mitigating circumstances by the defense. Unlike aggravating factors, mitigating circumstances are not just laid out by statute. They can be anything that basically supports an imposition of a life sentence. It can be things from the defendant's past of that nature. In this case, the aggravating circumstances the state is relying on go to each victim individually. And that's important for you to remember. Just like your verdict form and your finding during the guilt phase, you have to make findings as to each individual victim and to the aggravators applicable to that victim and that homicide. The first being Ms. Gunther. On Ms. Gunther, the state will be seeking one aggravator, to prove one aggravator to you beyond a reasonable doubt. And that is the aggravator of cold, calculated, and premeditated manner without the pretense of moral or legal justification, often referred to as CCP. The terms and the definitions of cold, calculated, and premeditated will be defined to you by the judge later on. But what the term basically means is that the murder was committed after calm, cool reflection, that the murder was committed with prearranged design to kill with a heightened level of premeditation, which allowed for a substantial time for reflection. And as I said, the evidence supporting this aggravator has already been presented at the guilt phase, and that was the murder of Ms. Gunther, how it was clearly planned out based upon the evidence, her being found naked without any identification, shot in the back of the head, no signs of struggle, things of that nature. But also it's the consistency between the 3 murders which show the CCP. This was a situation where it wasn't a random act or a shortly planned decision to kill. Each of these murders were basically on a script. Same type of victim, similar type of location, leaving the victim in the same condition at that location, leaving them without any clothes, identification, one single gunshot wound. So it is this script, this repeating script, which supports the state's CCP aggravator for Ms. Gunther. As to Ms. Green, we're also seeking the CCP aggravated. Again, that's cold, calculated, and premeditated. But we're also seeking the aggravator for a prior conviction of another capital felony or a felony involving the use or threat of force. And essentially that prior capital felony would be the conviction for the murder of Ms. Gunther. So the murder of Ms. Gunther is the aggravator for the murder of Ms. Green for that reason. And the same thing with Ms. Patton, the third victim. We are again seeking the cold, calculated, and premeditated aggravator. And we're also seeking the prior conviction for a capital felony. And for that, it would be the murder of Ms. Gunther and Ms. Green for Ms. Patton's murder. Those are the aggravators we are seeking for each one of the victims in this case. At the conclusion of this penalty phase, you'll see that all the evidence that's already been placed before you and that this evidence supports these aggravators and proves them beyond a reasonable doubt, and that they justify the imposition of a death sentence. Now, I do anticipate you're going to receive testimony and evidence and mitigation from the defense. There is likely going to be several family members and friends you hear from. You'll hear about the defendant's background, about his childhood, about his upbringing, things of that nature. I also anticipate that you'll receive testimony from defense expert witnesses about the defendant suffering from issues with what's called executive functioning. Executive functioning is basically a task that our brains do to make decisions every single day throughout our lives and be able to make rational decisions. And you'll learn from experts that the part of the brain that handles executive functioning is the frontal lobe. And the state anticipates that you'll hear testimony from the defense, from their experts, saying that in this case, Mr. Hayes does have executive functioning limitations, and that is because there is damage to the frontal lobe of his brain. But ladies and gentlemen of the jury, you will also hear from state expert witnesses if the defense does present this evidence. And the state expert witness, which includes a board-certified radiologist, will tell you that the brain scans of the defendant showed no impairment of the frontal lobe. Everything on his brain scans, which is a PET scan and an MRI, showed that his frontal lobe was normal. And please keep in mind, as you hear about mitigators and you hear the state's aggravators, that it's not a numbers game. This is not a situation where it's, well, there were 14 mitigators and 2 aggravators, so we're going to recommend a life sentence. No, it's the weight that you give to those items. So it's the amount of weight you give to an aggravating circumstances compared to the amount of weight you give to a mitigating circumstance. And I would submit to you that as we proceed through today and tomorrow, that the aggravators I've discussed here this morning and the ones that have already been, the evidence supporting them that's already been presented, outweigh any of the mitigation that will be presented by the defense. And after you've seen these aggravators and mitigators, Mr. Lewis will come before you in closing and will ask that after careful reflection, deliberation, and weighing all the evidence and following the law, that you return a verdict unanimously recommending that the death penalty is the appropriate sentence for the defendant for each one of the murders in this case from December of 2005, January of 2006, and February of 2006. Thank you.
Thank you.